rise, please. Hear ye, Court of Appeals, State of Michigan is now in session. The Honorable Colleen A. O'Brien, the Honorable Marion Bazi, and presiding the Honorable Brock A. Schwartzel. All persons having business here and draw near, give attention, they shall be heard. God save the United States, State of Michigan, His Honorable Court, please be seated.
Good morning. Welcome to the Michigan Court of Appeals. I want to welcome Judges O'Brien and Bassey to Lansing. And given the weather conditions, I very much appreciate all the hardy souls who were able to make it in this morning. We will get going quickly, but just a few ground rules. We've read your briefs. We've read the pertinent parts of the record. We've read the pertinent statutes and regulations and record. And so you do not need to repeat what's in your brief. This is an opportunity to hit a few of the high points and let us know if anything has happened in the interim between when you filed your brief and today. But most importantly, it's an opportunity for us to ask questions and for you to answer them. I think we have a couple cases. I'd have to look, I think towards the end, where we have children or people who have been involved in personal protective orders. If that's one of your cases, please be sure to refer to the appropriate persons by their initials. And with that, I will call the first case. The first matter for today, docket number 362410, People v. Smith. I believe we have a remote oral argument for Ms. Hilton.
Good morning, Your Honors.
Good morning. Can we get this louder?
Can you hear me better? I'll speak up.
Yeah, we can hear you better now.
Okay. Thank you. Rachel Helton appearing on behalf of Toriano Smith. I don't believe my opposing counsel has been endorsed for oral argument, so I'm not going to repeat the elements of my brief, as you said. I just wanted to use this time to briefly touch on a case that the prosecution cited in its brief. It was an unpublished case, People versus Zernick. From 2021, it was docket 353726. The prosecution relied on it as a comparable to the instant situation. And I wanted to specify that the facts of that case are not comparable at all to the facts in this case. That case, there was severe sexual touching. There was no way for it to have been anything other than for sexual gratification purposes. And in this case, the defense's theory was that there was an accidental touching and that it met the elements of the jury instruction because the touching could reasonably have been construed as having been done for sexual purposes. In Zernick, the touching clearly was done for sexual purposes. And so there's a danger in this case, as I said in my brief, that the conviction was based on Mr. Smith's words that evening, as opposed to his actual conduct. And the words were used to infer that he intentionally grabbed the victim for sexual purposes. So with that, I will just take questions and defer to my brief.
Okay, thank you for distinguishing that unpublished case.
Thank you.
No questions.
I don't think we have any more questions for you. We appreciate your time and the case will be submitted.
Thank you very much. And I appreciate allowing me to appear remotely.
Yep. Calling the second case on our docket today, docket number 369516, People v. Fuller. I don't believe the people are endorsed.
Your Honor is correct. I'm just here if the court has any questions.
Good enough. And then I think we have, is it Miss Bonso? I apologize if
I
got,
apologize, Your Honor. There was a little bit of a delay
how do you say your last name?
joining the panel. Oh, you did perfectly.
Okay. Can you put your name on the record?
Yes, good morning, Your Honor. Cecilia Carandango, bound to appear on behalf of Mr. Fuller. Your Honor, I did submit, so I submitted a brief with two issues. Mr. Fuller had submitted a per supplement. There was a remand for a Ginther hearing. We held that. And subsequently, I supplemented the argument. Again, I'm not going to rehash what was in the brief. I think it was pretty fully briefed, and I would rest on my brief unless there were any questions from the panel.
No, I think this case involved the issue of whether the RV was a residence. Is that correct? Or a domicile?
That's correct.
Okay.
That is correct.
No, I thought it was well briefed. Judge Bassey, do you have any questions?
No questions.
We don't have any questions at this time. For the prosecution, we'll let you come up and put your, make your appearance.
Thank you, Your Honors. Russell Babcock, I'm here on behalf of the people. We recognize we're not endorsed. We just came in case the court had any questions.
For the people,
No questions.
no questions.
Thank you.
Doesn't sound like there's much rebuttal there. And so,
No, thank you.
all right. With that, the case will be submitted. Calling the next case on our docket, the third matter, docket number 371604, People v. Maddox.
Good morning, Your Honors. Michael Frone on behalf of Mr. Maddox.
Morning, Mr. Ferone. Do we have, I think we have, Mr. Sauter? Yes. Okay,
Your
please
Honors,
proceed.
Thank you. I don't have anything to add to the brief as written. I'm here like to, appear in case the court has questions. I think it's my first time appearing in front of Judge Bazzi. I'm pleased to meet you. And, again, if you have questions, I'm happy to try to answer them, but I think everything's covered in the brief fairly, actually by both sides. So I guess the only factual dispute I would say is whether the police talked with Ms. Potter and knew that that she had heard her say she bought drugs from the other car. That I read the record differently than opposing counsel, but other than that, I don't think there's really a disagreement over the facts or issues, just only the conclusions. So,
Okay.
I'm sorry, what was that? You don't believe that, what was the factual dispute again?
in the prosecution's brief, they state that the police, when they arrived at the gasoline station, well, they did go to this other car. Ms. Potter did tell them, I bought drugs from, the defendant's car, and there were drugs inside her car. So now if that's true, and, I just think we should read the record differently. If that's true, that's a good argument by the prosecutor. I think at that point, that changes things. I can't argue they don't have probable cause to search my client's car. I just didn't read the record that way. I know trial counsel didn't read the record that way. It could be one of those records. To be fair to the prosecution on that, their witness did test. He was asked at one point, what was probable cause for getting into the defendant's car? He listed off a variety of reasons, and he did include that. So it could be one of those records that could be maybe read different ways. I'm not saying they're coming out of left field with that. Their witness did testify. He gave a list of reasons why, he thought there's probable cause, and he included, he said, and Ms. Potter told us, that they got drugs from that other car. So he's not coming out of left field with that. I just looking at the record as a whole, all the testimony, I didn't read the record in that manner. It would change things. If the court reads the record in that manner, I would have a much more, that would be a problem for the defense. I didn't read the record that way. I read the record as one officer went off and dealt with that car. The other officer went off and dealt with the defendant's car. And I just didn't I don't see where there was any testimony that, but I'll leave it at that. So.
Mr. Sauter?
Yes, good morning, judges. Drew Sauter on behalf of the people. At this point in time, I would rely on my brief unless there were any questions.
No questions.
All right, thank you. The case is submitted.
Thank you.
Moving to the fourth matter on our docket today, docket number 367215, People v. Clark.
Morning, Your Honors.
Morning.
Morning. Catherine Marcus from the State Appellate Defender Office on behalf of Deshaun Clark. I would like to focus I raised 4 issues. I'd like to focus on the identification issue and touch on sentencing briefly as well. First, concerning the identification issue, I want to address some of the prosecutor's arguments. So throughout that issue, opposing counsel refers to Ms. Nixon's failure to identify anyone at a photo lineup as a partial pretrial identification, and argues that this case is different because there was a partial pretrial identification. There's no such thing as a partial pretrial identification as a matter of law, and there was no pretrial identification in this case. Here at this photo lineup, Ms. Nixon, it was the second photo lineup in this case, Ms. Nixon looked at 6 photographs in a sequential array. She paused at Mr. Clark's. She said, "There's some things here that look familiar to me, but there are some things that are not." She thought his eyes looked familiar to her, but she thought the shape of his face, his jawline, his neck, the fact that he had a neck tattoo, all of those things were not like the person that she saw, and she moved on. She also looked at another photograph where she said, "There's some things here that make me uneasy. But this person's eyes, this person's hair, they look like the person, the jawline, but he's too light-skinned. This isn't the person." Ultimately, she made no identification. The form that was completed by Ms. Nixon and the officer says no identification. There was no pretrial identification in this case. Certainly, not every suggestive identification procedure is unconstitutional. Our courts have an analysis for determining whether a ID that was procured through suggestive means is still reliable enough. And though that process is looking at the gray Kachar, I'm not sure how to pronounce it, factors. That is how we would then look at the identification, the first in time identification that was made in court at the preliminary exam under suggestive circumstances, and decide, is this identification reliable enough that it is not unconstitutional, or is it unreliable? And here, when we go through those factors, there is nothing to suggest that the identification is reliable. There is no independent basis for the identification. She didn't know Mr. Clark. And if you really look at her ability to witness the perpetrator and what she said, how she was able to view him, it's incredibly limited.
Say that she got a decent look at his face on one side of the car. I think he was, if I remember right, it would have been on her side. She was in the passenger seat, and then he went around to the driver's side. And then I understand, there was the light that came out of the pistol, and that probably inhibited her ability to see at that point. But didn't she testify that she was actually able to get a pretty good look at him before the pistol light may have partially blinded her from being able to see him?
She says she sees him first outside of her side of the car. That's right. And she sees the person she knows, Markel, talking to the person that she doesn't know. She sees them look at each other for a moment. Fleeting moment. She says that this person has a hoodie that's pulled up and kind of tied tight. And that they come around then to her boyfriend's side of the car. And at that time, she said that because she was kind of slouched back in the car and her boyfriend was leaning forward, and her boyfriend's hair was in the way, that she could only see a portion of his face. And then a firearm was produced that had a flashlight attachment on it, and she was sort of blinded by that light and looked away. But she also testified and said during the lineup as well that she was really wasn't paying attention to him, this second person. She was looking at the person that she knew, and she didn't, she talks quite a bit at the end of the photo lineup about really her limited opportunity to observe.
And then going to the photo lineup, I mean, isn't it? I get the argument. It's certainly not compelling on its own, but isn't it at least somewhat probative that of, I assume the 12 people she looked at, because she looked at an earlier photo array, correct?
She did look at
I
an earlier
assume
photo.
that was probably 6-ish people. And then she looked at a second array, 6 different other people. And of the 12, there were 2 who kind of, she thought, there's something about that. Isn't that at least marginally probative? So maybe it wouldn't be sufficient on its own, but at least is something to throw into the mix when we're looking to see whether, there was other indicia of reliability with regard to this identification.
First, I would say I don't know if there was anyone in the first array that she paused on and looked at closely.
There's no evidence that she did.
That she did, correct. I think that certainly she could have testified, and the prosecution could have presented evidence at trial that there was a pretrial photo lineup and that she looked at Mr. Clark's photo. And while she didn't make an identification, she did note that there were features that were familiar. I think that is relevant evidence that could have come out at trial. What shouldn't have happened was she shouldn't have then been able to identify Mr. Clark for the first time in court a year after the offense, having seen him in that photo lineup where he looked somewhat familiar to her. And, it's not, the fact that he looked somewhat familiar to her is not surprising. They're both teenagers living in the same area that know the same people. So she could have, for very innocent reasons, said, this person looks familiar to me because she had seen him before. And then to be able to then come into court, having seen him in the lineup, but having rejected making that identification, and then identified him in court as he's now sitting there between his attorneys, and has been charged with this offense, that was improper.
How long was the in-court identification after whether we call it a partial identification or a pausing over his picture? What was the time frame between those 2 events, if you recall?
Yes.
Roughly?
The offense was in March of 2021. The shooting was in March. That lineup, that second lineup where she pauses, is about 6 weeks later in May. And then it's the preliminary exam is roughly a year after the offense. So it's quite a long
Like
time.
10 months after-ish?
At least, yeah.
Okay. And before we even get to any of this issue that you want us to look at, we have to decide whether Posey is retroactive, correct?
I don't think so, Your Honor. I think that could be a question in a different case.
Okay.
But here, because this case is on direct appeal, and our court, as recent as last year in Schaefer v. Kent County, reaffirmed that decisions are generally applicable to cases on direct appeal.
Okay.
But if that is something that the court is concerned about, I would appreciate the opportunity to brief it further, because I think that it is a complicated.
I don't think so. I was just, as I was looking through the issue, I just raised it, so.
Okay, thank you. Turning to the sentencing issues briefly. while, we argue that the sentence here was not a proportionate sentence, our argument is not as the prosecutor characterizes it. I want to just flip to that issue. That the court made an error of law because it sentenced.
Is this the mitigation memo?
There are two sentencing issues. The first sentencing issue has to do with the court's findings at sentencing when the court went through the Miller factors. Because Judge Cunningham here, the prosecutor stated that they intended to seek life without parole, but forgot to file the notice. And then asked the court to still sentence Mr. Clark to life without the possibility of parole and argued that Parks was wrongly decided. The court indicated that it wasn't going to do that, but it stated that it thought that were it able to sentence were a life without parole sentence on the table, that is how it would sentence, because its determination was that none of the Miller factors here were mitigating. And specifically, the court stated that age was neutral. Mr. Clark was 18 and 10 days. His chronological age had to be a mitigating factor. It could not be a neutral factor. The prosecutor's brief makes some distinction between a mitigating factor and mitigating effect.
When was this sentencing hearing roughly? What was it, 2024 or 2023?
It was July 31st, 2023.
I think a lot of law has happened. A lot of case law has come down. A lot of clarification has happened between July of 2023 and today. And if we agree with you with regard to your mitigation report argument, it's going to go back for resentencing in any event, correct?
Yes, that's correct.
My guess is, regardless of any judge's particular views on Parks and the 18, the 19, the 20-year-olds, that issue's been settled, and trial judges just need to go forth and sentence according to the law. So I don't know that that's something that we need to hash out today. What about the mitigation report?
Here, the ineffective assistance of counsel claim is not simply that counsel didn't, put his mitigation into a sentencing memorandum for the court, but that truly a mitigation investigation was not done in this case. And that's really clear from the record. Counsel sought an adjournment of sentencing in order to present a report with that mitigation investigation for the court. It did not do that when the court said, where is this sentencing memorandum? Counsel said, I thought a social worker from my office was working on it, was doing a mitigation investigation. That did not happen, but we were able to talk to Mr. Clark's mother. And so we would, and said, so we would have something to say to you, essentially.
Well, and I think if I recall correctly, you submitted, if it was I forget if it was an affidavit or if it was some kind of a report that essentially what you would try to present to the trial court below. And it does seem like that evidence in that filing is different than what the trial judge was led to believe based on the pre-sentence report. So
that's correct, Your Honor.
That would be the prejudice.
We attached a mitigation report to the brief and to the motion to remand of what a full investigation would have shown. That's supported by records, including school records, CPS records, and conversations with other people in Mr. Clark's family, including his sister, who primarily raised him.
Any more questions? Any questions? All right. Why don't we hear from the other side and you'll have time for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. Christopher Candela appearing on behalf of the Eaton County Prosecutor's Office.
Morning.
I think the court's really honed in on the main issue in this case probably the biggest issue in this case is the question about sentencing.
Well, before we get to that, what about this, the identification? And let's say we do apply, I forget the if it's Posey. But let's assume we apply that. Why was this in-court identification constitutional in your opinion?
Sure. So if Posey's applied retroactively or applied to this case, the in-court identification in this case is constitutional, not only because this wasn't a first in time identification in front of the jury. There was an identification at the prelim, which as of right now, binding case law says that that's okay. And I cite that case law in my brief. I appreciate that the Posey opinion comments on that case.
Let's assume we apply Posey in the preliminary exam context. Just assume for purposes of our conversation.
Yeah.
Why does that in court identification still survive in your opinion?
So in this case, when you look at you have to look at all of the evidence surrounding it. And not only is her testimony at the preliminary examination, but it's consistent with what she says at the pretrial identification. I appreciate that you're not going to find the phrase partial identification in case law, but that's really what this is. She goes through a photo lineup, the first set, and doesn't identify anybody. She looks at that second photo lineup. It is the defendant who she stops on, and she points out the distinctive characteristics about him that stand out to him: his eyes, his hair, his skin tone. The thing that stops him from saying this is the person who pulled the trigger is that jawline in the photo, that he has a thicker face. And I think through practice, we all understand that photos in a photo lineup
are not the most flattering sometimes.
Typically, they're older photos. And when she gets to court at the preliminary examination, that's when she has the opportunity to see him in person and sees that jawline that matches what her memory is.
Is it fair to say that she also paused on another person in that second photo array?
She did.
Okay.
The second time through, she paused on, I think it was the last photo in that array. And she points out his hair and I think it was his skin tone. But the way that she points that out, she's not saying, I think this could be the person as well. She's saying the person who shot him had this style hair, this color skin tone. As I interpret it and watch that video, I don't see her saying this could also be the shooter.
So even though partial identification is not a legal term of art, it's just as a practical matter, it's just one piece of evidence that we can throw in the bucket.
Correct, because I think what we're looking for here, if that partial identification is not enough in and of itself, it's certainly part of the independent indicia of reliability. And her testimony at the preliminary examination, she really explains to the judge that she's not basing her identification off the fact that this individual is here in this courtroom before me. She's basing it off her memory. And she's testifying about, I remember his eyes because of all these different things. And I remember his hairline. And the only thing that was different was that jawline. And I can see that jawline here today, and it matches. And that's who this person is. I'm not going to forget those eyes. And then there's all the other evidence that goes to corroborating that identification, the shell casings, the cell phone data, that he had on his phone photos of a firearm matching the description that she provided to the police, that he deleted off his phone the day after the shooting, photographs of him holding a firearm that matched the firearm that was used. All of that, it's not just what the victim or the witness sees as part of the identification, but we have to look at all of the other evidence that shows, yeah, this is him. This is the individual who was there, present, pulled that trigger. And then, of course, at trial, there's really no prejudice here, because at trial, the defense attorney presented to the jury that video of her taking that photo lineup and made that argument to the jury that, look, this isn't a credible identification. They presented that argument to the jury. So the jury was fully appraised of everything surrounding this identification, not just the in-court identification of saying, yes, that's the person who pulled the trigger.
What about the mitigation report?
The mitigation report in this case, I mean, it would have been ideal if defense counsel had provided a mitigation report to the court. I don't believe that it made a difference in sentencing here, because the allocution, the judge plainly said, you know, your attorney has allocated appropriately on your behalf. They've given me sufficient evidence to make a decision here.
But I mean, if I recall correctly, the trial judge recounted some things that were directly contrary to what was in the mitigation report. And maybe the trial judge would come to that same conclusion, but shouldn't the trial judge have at least had that mitigation report to consider?
I think the problem that we run into in this case is that the mitigation report that's being provided to this court on appeal is something that was investigated for significantly longer than a trial attorney ever would have had time to investigate and look into.
Okay.
I mean, I think we have to look at the objectives, that objective standard of professional standards. And if we had postponed trial or sentencing for a year and gave the defense attorney a year to go and do all this investigation, sure, he may have been able to present that information to the court. But I don't think that we can speculate that in a couple of weeks he would have been able to produce that same information. He's relying off the information that his client and his mother are providing him. And I think that's...
So regardless of whether defendant was prejudiced, you don't believe his defense counsel's performance was objectively deficient?
That's correct. He relied on the information provided to him by his client and his client's mother, and they didn't point him in this other direction. And I don't think we can place that burden on counsel to say you need to discover every bit of information that's possible out there if you had a year to conduct a mitigation investigation after the fact. I know the court has pointed out the case law has kind of changed as far as sentencing on youthful offenders. I don't know if the court has questions on that. I'm happy to address that.
It is what it is.
Issue. That's correct. I mean, the law has law is what it is. I do think in this case that the court did take into consideration his youth and the Miller factors that were addressed. She did go through them all. She addressed them. She recognizes that they're mitigating factors, but she also recognized taking into consideration the totality of the evidence in this case, everything before the court, that they had a neutral effect on the sentence. I do just want to correct one thing for the record. The trial prosecutor did not ask for the court to sentence to life without parole. In their sentencing memo, they indicated that life without parole would be a reasonable sentence, but that we understand the ruling of the Supreme Court. We understand that we've missed that deadline, and we expect this court to follow the ruling of the Supreme Court as they're directed to do. And I think that the judge herself even recognized that as sentencing.
I have a question. You
Yes.
said that you think the only reason the mitigation report was prepared is because they had a whole year. Isn't it common practice at this point to prepare mitigation reports for these types of cases? And aren't resources more readily available? And possibly a few years ago, but aren't resources more readily available now for attorneys?
I think mitigation reports are becoming more and more common. Yes, I think the distinction I was making is that it's the amount of time you have to investigate. A trial attorney typically, when you get done with a trial, you have a certain amount of time where they're conducting a pre-sentence investigation before you get to the sentencing hearing. It's not nearly as much time as you have when briefing a case for appeal and bringing it to oral argument. It's a significantly longer timeline.
But aren't there more resources available for defense attorneys out there? So they're not the ones putting together the reports, but they have access to resources and they have funding for those resources so they could prepare mitigation reports.
That's correct. Yes, there is. My understanding is that they do have access and funding to different sources that can assist with that. I don't think that it's unreasonable for a defense attorney to allocate orally to the court as opposed to presenting it in a written memo. And I think in this case, relying on the information provided by his client it's objectively reasonable for an attorney to do that. And if the client is not providing him that additional information, I don't, there's no case law that I'm aware of that says that an attorney has to go and employ a specific amount of resources or do a specific level of investigation into other factors surrounding the defendant. Mitigation's important, but I think an attorney should be allowed to rely on the information provided to him by his client and those who were involved throughout the pendency of the case.
Thank you.
Thank you.
Time for brief rebuttal.
Beginning with the sentencing issues, the defense attorney here didn't just have 6 weeks to do a mitigation investigation. He was representing Mr. Clark for quite a long time, over a year. He was representing an 18-year-old that was charged with felony murder and was facing a possible life without parole sentence. And that's likely what Mr. Clark would have been sentenced to if the prosecutor had filed that notice in time. So there certainly was every reason to begin doing some mitigation work in preparation for a possible sentencing. It didn't have to all happen between conviction and sentencing. And it's also objectively unreasonable for defense counsel to have only learned that the social worker that he thought was working on the mitigation investigation hadn't done anything right before sentencing. Presumably, there should have been some communication with that person, with that colleague during that time. Counsel could have and should have asked the court for more time to complete a full mitigation investigation in this case. There's nothing reasonable about proceeding with a sentencing as serious as this without having done any of that work. Opposing counsel made this point that the client should be able to provide the necessary info and said that a few times in the brief. If that was the case, that there would be sort of no body of law around ineffective assistance of counsel with respect to mitigation investigations like Rompia v. Beard, Wiggins v. Smith. These are cases where death penalty cases where trial counsel failed to do a mitigation investigation. And if it was just sufficient for an individual, someone to talk to their client and get sort of a rundown from the client, then this law wouldn't exist. Especially when you're talking about children, young people, people who are intellectually disabled or borderline intellectually disabled, who have prior experiences of trauma. You're not going to get all of the information that you need from a conversation with your client. And you're also not going to be able to show it to the court in a meaningful fashion if you aren't able to also show records that really demonstrate, that this, not just your client's word for what happened, but how that impacted their life. So ultimately here, trial counsel was deficient and for not doing that investigation. And it did prejudice Mr. Clark because the court was missing quite a bit of information about his life. And we can see that through how the court considered the Miller factors at sentencing.
Okay.
And then I will be very brief about the identification issue, but I wanted to respond to a few things. First, factually, Ms. Nixon did, when she paused on the second issue, she said, this one makes me uneasy as well. And the only difference
But why isn't that just a factual issue for the fact finder to consider, that you can't really take much away from what her initial pause in that second photo array, because she paused again on another picture and they kind of cancel each other out? Why isn't that just a factual matter for the fact finder?
Well, I think that when you have an identification that is suggestive, and for an in-court identification that's suggestive, it's not enough to just tell the jury that the in-court identification is suggestive and show them a video of the photo lineup, right? There's a reason why trial attorneys move to suppress suggestive identifications. And that's because we know, and we know from research, that eyewitness identifications are very compelling to juries, and that jurors don't really fully understand how eyewitness identification can be compromised and why it is not as reliable as it feels. When you have a witness saying, when I look somebody in the eyes, I remember them forever, right? And then burst into tears, that is really compelling testimony to a jury. And so it's not enough to just then tell the jury, look, she didn't make this identification when she did this pretrial lineup, and look, she paused on this other person as well. This is suggestive, right? An objectively reasonable attorney would move to suppress the identification so that that question is never before the jury in the first place. And we know from the record here that that's what trial counsel was trying to do, essentially, because at the motion for directed verdict, counsel argued to the court that the ID was so suggestive that the court should grant a directed verdict. Thank you.
Okay, thank you. That case is submitted. We appreciate the oral argument this morning. It's been very helpful. So thank you. Moving on to the fifth matter for today. Docket number 371683, People v. Elkins.
Good morning, Your Honors.
Morning.
Michael McCarthy, P30169, appearing on behalf of the defendant appellant Dennis James Elkins. I raised two issues in the brief of appellant. I will rest on the question number one about sufficiency. I would just like to make a couple of remarks regarding the second question. And that is surrounding the DNA evidence or YSTR evidence that was presented, because the people presented two witnesses who are experts, and one of the first person who was a DNA expert stated that there was a 7.66 billion to 1 that it was not chance, that it was not Mr. Elkins' DNA in the complainant's underwear. And there's two donors, and apparently the two donors are distinct from my reading of the record. And so there's some other person who's a male who has something to do with the depositing of DNA material in this 11-year-old child's underwear. The YSTR evidence includes all of the males in Mr. Elkins' line, his father and his grandson, his son, and if he had brothers, if he had nephews, all of those males in that same descending order would be included. And I think that is the basis upon why defense counsel brought the motion for a directed verdict or a new trial at the time, well, immediately before the sentence was imposed, but he filed it in between the time of the verdict and the date of sentencing. Because the people, or the defense and the people for that matter, didn't have access to, I believe it's CF, who was the person identified during the trial by defense counsel as the actual perpetrator.
That was the defendant's grandson, correct?
That's correct. And so his YSTR is going to be, if I understand the science correctly, and I don't propose to be an expert on these things of biology, but from what I've read, that would be exactly the same. So it doesn't make Mr. Elkins unique in this circumstance. Now, I understand, and I'll readily concede that there's testimony from AF, I believe is the initials of the complainant, to the effect that she makes an identification of Mr. Elkins. However, also in the testimony of her mother, she said, and this is at pages 105 and 106 of the December 12th, 2023 transcript, she said that her daughter's had an imagination that, quote, reached the stars. So here's a person who knows her, I would say, presumptively better than most people. That's how she described her own daughter having this imagination. And Once she's told this story, I can understand how people become ingrained in the story. There are two people who came to testify in rebuttal to the effect that the CF, that individual, grandson of Mr. Elkins, was not present that day. But who are those people? What interest do they have? It's his own mother and her mother who come to court and testify to that
It all
effect.
seem like, I mean, very good arguments for a jury, but the jury made a finding. And I mean, I get it. I mean, there's evidence that you have that go the other way, but there's also evidence that points to your client. And why isn't it, we just have to defer to the jury's finding here?
Well, I think that one of the things the jury didn't have is the benefit of the thing that defense counsel was asking for, and that is DNA from CF.
But
And
Mr. McCarthy, isn't it true that the defendant refused to cooperate with the detective that was investigating and never mentioned to that detective, my grandson was in the house, or my grandson should be tested? He never mentioned it until trial, I believe.
that's, I think, an accurate reading. I will submit this in response to that. Mr. Elkins, I don't want to say that this makes him old because he's 2 months younger than I am, but he's going to be 73, I think, on the 31st day of March. And in 26, it appeared from the record, what I read about him being a reclusive individual. He's either stayed in his room or he stayed down in the basement. He didn't interact with other people. And I think that that is of a piece with him not speaking with the police. And I'm not a psychologist, but I'm just looking at what I could glean from the record. And that's the explanation that I would give. Why did he fail to cooperate? It wasn't a good idea, but I don't know that he was listening to anybody at that point, and he wasn't represented by counsel at that point either, I don't believe.
Can't blame the prosecutor, though, for not having evidence from the grandson if he was never mentioned before.
Oh, that's a fair point.
Yeah.
But now he is mentioned, we have a trial, and at the conclusion of the trial, the argument's being presented to the trial judge that we want to either have a verdict notwithstanding a judgment notwithstanding the verdict, or we want to have a new trial, and this is a reason why. And this evidence would be helpful to showing this man's innocence. And I think that that is where, and now we get to a denial of a motion such as that. I'm submitting that that is the error. That's why that is the way that I put the second question together. There's one other final point that I want to make regarding Mr. Elkins, and that is I didn't argue sentencing here at all. It's pointless, but I did include the pre-sentence investigation report as exhibit or attachment A or B rather, and the sentencing information report. And the reason I did that was because when you go through Mr. Elkins' criminal history, this is the only thing in what was about 70 years at the time this allegedly took place of life. He'd never been in any trouble of any shape whatsoever. Secondly, when you look at the guidelines, that reflects that fact. Even though this is a Class A felony, he's got a guideline range that's 27 to 45 months as a first offender. That, I think, underscores why it is that the motion for a new trial should have been granted, because there's something that just isn't right here. And this man, he'll die in prison because he was given the minimum sentence of 25 years, which is mandatory. And the chances of him being around to 95 are probably pretty slim.
Okay.
Do you have any other questions?
Questions?
Thank
Thank you. We appreciate it.
Appreciate it.
That case is submitted. I know we had some lawyers who were late because of an accident, and so, but I've been told we're ready to go on number 6, 7, and 8. Okay. Calling the sixth matter for today, docket number 354101, People v. Frinkle.
Morning, Your Honors. Marielena
Morning.
David from the State Appellate Defender Office on behalf of Ms. Frinkle.
And we appreciate both of you being here, given the roads. Thank you.
Yeah, we were panicking together and we made it together, so happy to be here. Trial counsel here engaged in a series of confusing actions, most notably telling the jury this case was about self-defense and that they would be instructed on self-defense, then abandoning that theory of defense without explanation and without an immediately discernible trial strategy. Those are the words of this court in the prior opinion in the interlocutory appeal that was taken in this case. This case is about the bizarre actions of defense counsel regarding the handling of self-defense in Ms. Frinkle's case. I want to reiterate this point very strongly because it's a point that the trial court got wrong in the opinion for denying the motion for new trial. This case is not about whether defense counsel was ineffective for failing to request a self-defense instruction. And it's not about whether the trial court erred in failing to give a self-defense instruction. And it's not about whether Ms. Frinkle would have been acquitted had her jury been instructed on self-defense. This case is about one question, and that question is whether trial counsel's mishandling of Ms. Frinkle's self-defense at trial resulted in prejudice. Here, defense counsel did request the self-defense instruction, did promise the jury that it would hear about self-defense, and did successfully argue for a self-defense instruction, and then recklessly abandoned it. The trial court also did make a finding that there was sufficient evidence to give the instruction. So the trial court was willing to instruct the jury on this defense.
Just from my own understanding, there's two ways to look at this, and I just want to understand which way you want us to look at this. One, that defense counsel really should have pursued a self-defense theory because, you know, that's what the attorney said at the beginning, and got the jury instruction, and really should have just gone through and argued self-defense. The other way of looking at this is that basically losing credibility in front of the jury by saying, you know, they were going to argue self-defense, getting the self-defense jury instruction, then basically having it removed by the judge, and then the prosecutor making a flip remark about, well, we know why they did that. And that somehow that poor performance by the lawyer in I think your opinion undermined credibility of the defense in front of the jury. Which one are you arguing? Are you arguing the first should have just gone with self-defense full bore and that was prejudiced because he didn't, or really shouldn't have brought it up in the first place and it was loss of credibility?
Well, a version of the latter, Your Honor.
Okay.
Definitely the latter, not the former. The latter in that the deficient performance comes from the series of actions that defense counsel took, all contradictory to one another when in front of a jury. The first being promising the jury that he's going to be arguing self-defense. So that shouldn't happen if you're not later going to argue self-defense. That is not reasonable professional performance to tell the jury this is a case about self-defense. You're going to get
But
self-defense.
if the evidence comes in differently than originally anticipated, there's case law that says that that's acceptable for the defense attorney to change their strategy.
Except for the fact that we're talking about one piece of evidence, which is Mr. Goodwin's testimony that Ms. Frinkle had Mr. Bearden in a headlock during the fight. That's what we're talking about when we're saying the evidence came in differently. There are two problems with that. One, putting somebody in a headlock during a fight does not negate self-defense. That's the one thing. And the second thing, most importantly, is trial counsel admitted at the evidentiary hearing he did not attempt to interview Mr. Goodwin. He did not interview Mr. Goodwin. Trachtenberg tells us that trial counsel's decisions and strategy throughout trial and leading up to trial cannot be insulated by a failure to investigate. So trial counsel's putting on this air that, oh, he was surprised that Mr. Goodwin said this thing and it completely toppled his entire theory of the defense for Ms. Frinkle. But trial counsel didn't even attempt to investigate this case before developing his theory. So his decision cannot be insulated by his failure to investigate this case and interview the only eyewitness. No reasonable defense attorney should be going to trial without interviewing the only eyewitness to the crime. And trial counsel did that, and then is attempting to say, and so therefore I could just change my theory willy-nilly throughout trial because he surprised me with this one piece of testimony.
What about the prejudice prong though? Because even if we were to agree with you that defense counsel could have done a better job during trial and maybe pre-trial by investigating, by talking with the witness, there did seem to be quite a bit of evidence of guilt here and very little evidence of self-defense. And so how do you get over the prejudice prong of just an overwhelming amount of evidence, including video evidence, as I recall?
Yeah, I think we have to go back to the manner in which trial counsel abandoned this self-defense, of presenting it to the jury as this is what you're going to hear, and then recklessly abandoning it. And when we had the evidentiary hearing, trial counsel admitted that is a mistake I made. I shouldn't have abandoned it in the way that I did because, and if you see his trial counsel's testimony at the evidentiary hearing, it's because I shouldn't have done that because then the prosecutor was able to capitalize on that in front of the jury. The prosecutor then was able to say, first go in to say to the jury, you're going to hear about self-defense in this case. That's how she began the, I'm sorry, I don't know if, that's how the prosecutor began the closing argument. Defense counsel then objected. They had a bench conference in which defense counsel said, I'm no longer going to be asking for self-defense. And the judge said, well, if you're not going to ask for it, I'm not going to read the instruction. They go back out and the prosecutor then says to the jury, well, you're not going to be hearing about self-defense and you know why. And defense counsel stands up and says, objection, some version of, well, now, Your Honor, the jury's going to believe I believe in my client's guilt now that the prosecutor's saying these things. This is all happening in front of the jury. And so the manner in which trial counsel abandoned self-defense was reckless and prejudiced Ms. Frinkle because the jury is now hearing the defense counsel giving up this particular theory. And not that she would be completely acquitted of this case based on self-defense, but defense counsel also said his entire theory of this case, as he kind of wavered throughout, he repeated multiple times, I wanted to argue flavors of self-defense and elements of self-defense to leverage a manslaughter conviction.
But again, I guess I get back, there was quite a bit of evidence of murder here. And, how do you, part of the prejudice prong is we look at what, even if self-defense was never raised, but this kind of more nuanced version of it wasn't self-defense, but it was at least mitigating, maybe down to manslaughter. There was a lot of circumstances that would call into question that. The age difference was quite a bit. This was I don't want to say older gentleman, because I don't want to upset, somebody who's just going to turn 73 in a couple months. But there was a big age difference. He was trying to get away, towards and there was video evidence, as I recall.
Video evidence of how the decedent was after the fight, not of the fight.
Okay.
But there's a lot, you said there's a lot of evidence of murder. There's a lot of evidence of a lesser included offense of manslaughter as well. And that is the point of how the self-defense comes into play here and how defense counsel was attempting to use a self-defense to get manslaughter. So we're talking about the difference between second degree murder and manslaughter, and Ms. Frinkle was convicted of second degree murder. The prejudice comes into play because the circumstances of the facts are, yes, Mr. Bearden was 63 years old, Ms. Frinkle was 21 years old. He's a man, she's a young woman. He was drunk. The prosecutor is making issue of his blood alcohol levels. Ms. Frinkle didn't know his blood alcohol level at the time. She knew that she encountered a man, they got into a fight, he was yelling at her, he called her the N-word, she shoved him, he punched her, and a fight ensued. So it was a chaotic situation where a young woman is fighting an older man in the middle of the street. and ultimately does stab him to get away. And yes, there's also testimony, people were trying to get away. He tried to get away. She, engaged in the fight. But we are looking at this as outsiders saying, okay, this happened in this first 10 seconds of the fight, and then this happened in the next 5 seconds. They're fighting until the fight is over. And there is a lot of evidence that this is a case of manslaughter. Defense counsel testified at the evidentiary hearing. Every single time he spoke with Ms. Frinkle, she was crying. She was remorseful. She did say that she deserved to be punished, but that could be indicative of a self-defense claim. That could be indicative that this is manslaughter. And so bringing to the point too of where the prosecutor talks about the Johnson case, I want to just kind of highlight to the court that I don't think the Johnson case is at all applicable here, where in Johnson, it was a situation where defense counsel yielded to the desires of the defendant in that case. This case is very different than that. If you read the evidentiary hearing and the testimony from that, I asked defense counsel point blank, did your decision not to argue self-defense in this case have anything to do with what Ms. Frinkle did or said to you? And he said no. And so the prejudice factor, it also leads into the second argument, which I will address if that's okay. But it's the wrong question is the question is not whether she would have been acquitted had the jury gotten self-defense. It's whether there's a reasonable likelihood that the outcome would have been different. A different outcome could be they focused more on Olivia Caston's testimony because that was a self-defense testimony. Maybe they asked to read that. Maybe they had other questions related to the verdict before they reached second degree. The outcome could have been voluntary manslaughter. There's evidence for that conviction. And the manner in which trial counsel just recklessly abandoned self-defense after promising it to the jury did prejudice Ms. Frinkle.
So just for my own understanding, is it fair to say that you believe what should have happened is self-defense should have never been raised by defense counsel, and any self-defense like evidence should have been offered up by defense counsel in the frame of a manslaughter, a lesser included?
No,
so never even bring up self-defense.
No, Your Honor.
No.
It never should have promised the jury that they would be instructed on self-defense. The jury doesn't understand the nuance of when you tell a jury you're going to hear this case as self-defense, you're going to hear about that.
Where precisely did defense counsel err? So if defense counsel didn't err at the beginning by saying, we're going to show you self-defense, I mean, is that where the error was at?
Defense counsel erred a couple of times. One, in promising the jury that they were going to hear about self-defense, and two, in recklessly abandoning that instruction in the manner that he did so that the jury could hear all about the fact that defense counsel was giving up this defense that they were promised in the first place.
Okay. So again, I'm trying to make sense of this. In the way that it should have gone forward, I don't think you can say, well, it was fine to offer it at the beginning as long as they stuck through it, because then we just look at, okay, was there enough evidence of self-defense here?
Mm-hmm.
And I don't know that there is, because your stronger argument seems to be really this was a manslaughter, should have been a manslaughter defense all along.
Mm-hmm.
I'm trying to figure out what exactly you're saying here.
Well, Your Honor, it could have been multiple things. It could have been that he argued self-defense as an acquittal. It could have been that he argued self-defense to leverage a manslaughter. You can argue alternative things to a jury. So I can't just pick either or, because different things could have been presented. And I think that the main point of the deficient performance is if you take a step back at how trial counsel prepared for this case, and the lack of investigation, the lack of a coherent case theory, the lack of anticipation of things that could come up at trial. He did not go to trial with a coherent theory and then attempted to kind of sprinkle it in here and there in a reckless manner and then abandoned it recklessly.
So once he promised the jury that they would hear self-defense, he should have stuck with it. and should have gotten the self, and should have insisted on the self-defense instruction and gone through with that, argued self-defense, but in the alternative, at least manslaughter. Is that a fair summary of your position?
It's one,
It's what counsel should have done?
It's one summary, but he also could have, we're also looking at the fact that he vehemently argued for this self-defense instruction over the objection of the prosecutor. So before they went to closing argument, he told the judge, there is evidence of self-defense in this case. We have Ms. Caston's testimony. This is a self-defense case. I want this instruction. The prosecutor objected. Defense counsel got that instruction. My point is, defense counsel was vacillating the entire trial until there was just no longer time to vacillate anymore. And he got caught in that when the prosecutor started saying things to the jury about self-defense. No reasonable attorney would abandon a defense as big as self-defense because of testimony about a headlock, because of a minor thing that he reviewed between the minutes that passed when he asked for the instruction and then went on the record. Those are mere minutes that passed during that time. And he is wanting us to believe that there was some big revelation that he couldn't have anticipated, even though all of the evidence was the same except for one comment about a headlock.
So it's the vacillation. There could have been a couple different strategies that might have been effective below, but your main criticism is that it was the vacillation that really hurt the credibility of the defense in front of the jury. Is that, I mean, again, I'm not trying to put words in your mouth, but is that it's really that going back and forth that undermined any effective defense?
It's close, but it's nuanced. The vacillation happened because he didn't investigate, because he didn't go to trial with a solid theory, because he didn't properly anticipate evidence as it was coming in, and because he, in his vacillation, recklessly allowed the prosecutor to imply to the jury that this defense attorney believes in his client's guilt.
Okay.
Second argument about voluntary manslaughter. The issue here is that criminal jury instruction 16.8 is inaccurate. So that is my position, that 16.8 is inaccurate. The trial court, in denying this issue, essentially said the jury instructions are accurate because they're standard jury instructions. But the note to the standard jury instructions says that they can be inaccurate. So we should all be, checking the law and making sure that the instructions are accurate before we're reading them. And so the problem is that 16.8, which was read to Ms. Frinkle's jury, the instruction on voluntary manslaughter, is the same exact instruction for second-degree murder.
But 16.9 was also read, correct?
Yes, it was.
And 16.9 seems clear, and it seems, I think, correct. I'll be the first to admit I don't understand 16.8 either. I don't understand how we call two different things the same thing. But be that as it may, once 16.9 is read, isn't that, I mean, that's the clarification that a defendant would be entitled to, and they got it, or he got it, or she got it.
Sorry, Your Honor. I think jury instructions can be confusing to jurors. And when they're being read, especially what's confusing is when they're wrong. And especially what's confusing is when the defense counsel's asking you to go for voluntary manslaughter, and you get two versions of voluntary manslaughter. One is completely wrong and mirrors second degree, and the other one is correct. So I do agree that eventually a correct version was read, but I want to point out that defense counsel did not, at the evidentiary hearing, he said he admitted that the instruction was wrong, 16.8, and he does not know why he didn't correct it. It's something that got past him. So that was not a strategic choice on his part to let an accurate jury instruction be read to the jury. And so that's deficient performance. And the prejudice is he's asking the jury to convict Ms. Frinkle of manslaughter with a wrong manslaughter instruction for some reason read to the jury. Yes, in addition to the right one, but if you're reading them all in conjunction, it just leaves you with a big fat question mark. What actually are these elements here? So in this case, Ms. Frinkle was deprived of the effective assistance of counsel by several instances of deficient performance, including allowing the wrong jury instructions to be read on the charge that defense counsel was ultimately asking the jury to convict on. Thank you.
Thank you.
Good morning. May it please the court, Matt Way from the Jackson County Prosecutor's Office on behalf of the people.
Morning.
Good morning. I have a lot of notes, so I'm going to try to hone in. I appreciate Judge Schwartzel, your questions, because I've kind of had this same confusion on what exactly the argument is here. So I'm going to try to address the two issues I think that have been raised, the promising and the self-defense first. And I think we specifically need to go to the record for this. I think it's really important. In trial counsel's opening statement on page 35 of volume 2, he says, quote, "I'll be asking for an instruction on that." He doesn't promise an instruction. He says, "I'll be asking instruction or for an instruction." He also says that there's a self-defense component. This is again on page 35, but it's more important as to the issue of manslaughter. So I think the representation that he's promising them, they're going to get self-defense, this is going to be a self-defense case. I don't think that's accurate. And then on page 37, he says, or he talks about how they're going to talk more about self-defense and manslaughter later, but he wants the jury to hear the evidence first. And so this notion that he went in without a strategy, I don't think is accurate, because I think in this, specifically on page 37, he's doing what any good trial attorney does. He's leaving himself open to like, hey, this is what I think is going to happen, but just in case, we got to hear the evidence. We'll talk about it more later. I think anyone who's been a trial attorney knows that you have to be flexible. You can't overpromise an opening statement. And I think that's what trial counsel did. In terms of abandoning the self-defense, trial counsel admitted he shouldn't have done, or he should have let the court and the prosecutor know he made a mistake there. I don't think that rises to the level of deficient.
What are you referring to?
He should have let them know he wasn't going to request the self-defense instruction before openings or before closing statements happened.
I mean, I think the jury would have never been the wiser if the plaintiff or if the prosecutor hadn't made a somewhat flip remark that may have torpedoed a conviction.
I totally agree, Judge Schwartzel, and there's been no claim of prosecutorial error or prosecutorial misconduct, so that's been an issue that's been waived. The trial court specifically basically sustained the trial counsel's objection, kind of chided the prosecutor for making that remark. So I agree, it was kind of the prosecutor who caused whatever error. And as we know, I mean, this jury was instructed that the trial attorney's statements are not evidence. As everyone knows, we know that juries are presumed to follow their instructions.
What about the issue of the jury instructions? Because again, I mean, I will be the first to admit, I wasn't a prosecutor or defense counsel, so I don't suggest I've had long experience, but just reading 16.8, it does seem a little confusing.
Yeah, I think it clearly should be much clearly written. I know there's actually a proposal for an amendment. They kind of changed it in.
But what about the argument that by reading 16.9, any confusion caused by 16.8 was clarified because 16.9, as I read it, is much clearer.
And that's our position, and that's our position in the brief. And I would just note, I personally think that 16.8, while not entirely clear, I do think it's an accurate statement of the law, because the one distinction that it makes, the one difference between 16.5 and 16.8 is that second degree murder can't be done under circumstances that reduce it to a lesser crime. Those circumstances are then detailed in 16.9. That language, reducing it to a lesser crime, isn't in 16.8, the manslaughter instruction. It shouldn't. That if that said that, then that would be completely inaccurate. But I do think, while I guess we're here.
So is it fair to say 16.8 is an accurate statement of the law, but it's lacking context.
I think that's
And then
true.
16.9 is what we look to for the context.
right. And if you just read, I know, I don't remember the name of, actually, I have it. Defendant cites an unpublished case that's Thingthum, I believe. And in that case, this court, I can't remember what I can't, but the Supreme Court, our Supreme Court ended up remanding it. And what happened in that case was 16.9 wasn't read at all. Only 16.5 and 16.8 were read. In that circumstance, I would agree. There's clear error there because you don't have the context of what are the circumstances that reduce this secondary murder to manslaughter. We have that in this case. They were all read. The use note wasn't followed, but I think you get a more complete picture by reading 16.5, 0.8, and 0.9. Just a couple other things I wanted to mention. Sister Counsel kind of said, Mr. Goodwin's testimony, it was just kind of, all he introduced was the headlock. Well, it wasn't just that she had him in a headlock. She had him in a headlock and was stabbing him repeatedly. And Mr. Goodwin says at one point that he kind of yells at them. He says, let him go, let him go. Which I think goes to not only the self-defense, but just the manslaughter. And the other manslaughter point I would make is that I won't use the language, but afterwards, she makes this comment saying, I left that expletive in his face.
Left the knife in his
Yeah,
face.
that doesn't strike me as somebody who's acting out of passion. It maybe a little out of anger, but not out of passion or out of passion to reduce this to manslaughter.
Okay.
I believe that covers everything. I'm happy to answer any other questions the court may have. Okay.
Thank you.
Thank you very much.
You have time for a brief rebuttal.
Thank you. I just want to point out with the jury, when I say promised self-defense, I don't mean to say defense counsel said, I promise you, you're going to hear about self-defense. This is like when police make promises of leniency. They're not saying that word. But the point is, on a jury on a receiving end, they're not picking up on the nuance of components of self-defense, or we're going to roll self-defense into voluntary manslaughter. A jury with no knowledge of it hears self-defense, they think they're getting self-defense. And so that's what I mean when I say that. The point about abandoning it and the prosecutor making a flippant comment, the prosecutor did what prosecutors do. I see no problem with the prosecutor saying like, oh, you see that the defense counsel didn't argue. Like, that's exactly what we would expect a prosecutor to do. So that's why there's no cross misconduct issue here. It's on defense counsel to prevent that type of inflammatory mark reaching the jury. Lastly, on the manslaughter in terms of not seeing passion, this is a situation of, yes, a drunken brawl where Miss Frinkle was called the N-word and punched in the face first by a man. So there are lots of indication of inflammatory language back and forth during the fight. It is a textbook case with evidence supporting a manslaughter conviction.
Okay. Thank you. Any other questions? All right. That matter is submitted. Moving on to the seventh matter for this morning, docket number 374844, People v. Holmes.
Good morning, Your Honors. McKenna Thayer with the State Appellate Defender Office on behalf of Mr. Holmes. I'm going to mostly rely on my brief, but make a few points in response to the prosecution's brief, starting with OV7. Both the case law and a gut check, a logical look at these facts, suggests that OV7 should have been scored at 0 points instead of 50. The first argument that the prosecution provides is that in the Liddick case, they compare where it's a strangulation case where there was a belt used and that use of a weapon, wasn't an element of the crime. And so that use of a weapon elevated it to excessive brutality. This is not so. OV7 does not contemplate the use of a weapon. And in fact, the legislature already contemplated that in OV1, which Mr. Holmes was scored. So the fact that a weapon was involved is not enough under OV7 to necessarily include excessive brutality.
Didn't he kick him while the victim was on the ground repeatedly to the point where the eye socket was disconnected?
We're not sure when the eye socket was fractured. There was fighting before the kicking. He did kick him twice after Mr. Kane had fallen. But I'll point out that Mr. Kane continued to hurl insults and threats at Mr. Holmes before and after he had fallen down. After he had gotten back up from that and Mr. Holmes, the fight had stopped, Mr. Holmes asked him if they should call an ambulance, and he responded with an FU and told him as he drove away that he was going to kill him. About 6 days after we submitted this brief, this court decided a very similar case, another assault with intent to do great bodily harm, that explicitly looked at OV7 and excessive brutality. This is the Vahovic case. This was this July, and the docket number on that is 365933. And this court there, when looking at OV7, said in the facts of
Just
this.
for my own, is this
Yes.
published or unpublished?
This is an unpublished case. Otherwise, I would have submitted it as a supplemental. But in that case, it was in a prison, and the defendant there tied a lock to the end of the string and then approached an officer from behind and began beating him with that lock until he was subdued. And this court said that defendant's conduct did not rise to the level of cruelty that is required to assess points for OV7. Although it was a violent attack and defendant struck the officer several times, it's clear that the blows were delivered as part of the attempt to inflict grievous bodily harm. They're not excessively brutal, but beyond the violence inherent. And that's what we have here. This was Mr. Holmes, and it wasn't a perfect self-defense. He wasn't acquitted on that, but he was acquitted of assault with intent to murder. So we have this ceiling of how brutal his conduct would have been because it didn't cross into that murder category, that intent to murder. And so this isn't one of those cases, like I said at the beginning, this is a gut check. This isn't savagery. We don't have these heinous facts. This was a mutual fight. It happened at Mr. Holmes' house where Mr. Kane, the complaining witness, came to try to take Mr. Holmes' child. The fight lasted as long as necessary to get Mr. Kane to leave the house. Mr. Holmes did not chase him down afterwards. He did not continue beyond that. And I will also point out that the first punch was thrown by the complaining witness here. This was not a brutal or heinous attack. This was a mutual fight. The prosecution also talks about, multiple stabs or multiple kicks means that everything beyond the first one became excessively brutal. Like I just said, I don't think that tracks with these facts because the fight only lasted until Mr. Kane left. But I also think that kind of fails because if there was only one stab or one kick, I don't think we'd be seeing an assault with intent to murder charge. One stab or one kick is probably more like a simple assault. So there is inherent brutality involved when you have a mutual fight like this, when you have intent to do great bodily harm. That's brutal. This is not one of the cases you look at that kind of makes your skin crawl because it's so heinous or is excessive.
Okay.
And I'll turn to OV19 very quickly. I want to come back to the preponderance of the evidence standard that's required to score this. The evidence here shows that the scissors were not used in this crime. There's no blood.
I don't know that we know that.
I would say on a preponderance of the evidence standard, it's definitely not a preponderance that they were.
Well, it does seem odd that during a jailhouse call, he mentioned this random pair of scissors that just happened to be on a roof, that just happened to be wrapped in cellophane or something like that. I mean, I get, it's not beyond a reasonable doubt, but I'm not sure that it's not a preponderance that those scissors might well have had something to do with this.
I would agree with Your Honor if that was the facts here. Mr. Holmes was not on a jailhouse phone call saying, go get the scissors from the roof. He told his girlfriend to go retrieve money from a location above the window, and there was no money found there. So I think there is some chance that the scissors were not what he was talking about. But we have forensic evidence that shows and suggests these scissors were not the sharp object used. We know the police were looking for knives and tested those. They tested the scissors. They did not find any traces of blood, not even trace. There was no fingerprints on the saran wrap. There was no comparison of the saran wrap to what was found in the kitchen that they're claiming, where he would have cleaned and wrapped those scissors. There was no fingerprinting done on that saran wrap. There was no actual connection. And we have him going to the hospital, you know, the complaining witness. We had testimony from the doctor that treated him. We don't have any indication of what type of stab wounds he received. We don't know how deep, what angle, what type of
What
object
about
it could have
cleaning off
been.
the shoes?
Sure, the clean off the shoes, I think, is not the most genuine claim that I've seen. I think that
What do you mean?
it's an argument only to get the 10 points of OV-19, but I don't see how he's already been booked in. He's already been arrested. He's put into a holding cell. His possessions have been taken. How is Mr. Holmes supposed to know then that they also meant to bag and take his shoes? He's in a crowded cell with other people, and so he's cleaning himself up.
My understanding was that there's some information that he had blood splatter on his shoes, and then there's evidence that he was seen wiping off his shoes.
Yes. That's correct. He'd already been booked in and arrested at that point. The officers had already taken his possessions. So they've already done the investigation to collect the evidence. He's cleaning his shoes because he's in a crowded cell with other people and was tracking blood.
Right, but they might not have collected all the evidence. They might have, you know, at some point come back and said, "Oh, look at your shoes. Let's take your shoes and we'll do some DNA testing."
We do know that the officer knew about the blood when he was booked into the cell and didn't take his shoes. So under that same logic, we know that the officers knew before he was put into the cell where he had the opportunity to clean them, that there was blood on his shoes. We have testimony from that officer.
Okay.
So it's kind of like.
I don't get the point. I mean, clearly their investigation is not over just when they book him. And so if he is destroying evidence after he's being booked, I don't think we disregard that because, well, he's booked and, you know, their investigation was over. I mean, investigation was ongoing.
Sure. OV-19 is when Mr. Holmes is doing specific actions to interfere with the administration of justice.
Which would be destruction of evidence, correct?
If he was trying to destroy evidence, he was cleaning his shoes because he's in a crowded cell with other people and he's cleaning them up. I mean, he did get rid of the blood evidence, but he's not interfering with the investigation because he's sitting here thinking, okay, they've got me, they took my belongings, they have what they needed. They could have taken his shoes. At that point, he's not thinking, oh, I'll quickly, you know, get rid of the blood before they come back in. I think the police had the chance to investigate and take those shoes. And so to hold it against Mr. Holmes that now that they didn't, he's destroying evidence, I think is where the split comes. I think there's plenty of reasons that someone could be cleaning themselves up when they're in a cell with many other people, and they have bodily fluid on them like blood. There is a genuine, you know, I can afford Mr. Holmes the dignity to think that he wanted to clean himself up when he's sharing a room with all of these people.
Okay, you have time for rebuttal.
Morning again. Matt Way from the Jackson County Prosecutor's Office on behalf of the people. On OV-19, real briefly, number one, it doesn't make a difference in the ultimate scoring. So the notion that we, I won't even get into that, but.
That is a loud phone. That'll wake you up in the morning.
I do want to just make the record clear because what was just represented, I don't think is the full story at all. What was testified to at trial is that Mr. Holmes was on the jail phone call saying that he was surprised a weapon was not recovered and that he would be mailing Brianna, the person he's talking to, a letter. That letter is then intercepted 18 days later. It says that she needs to get not just the money, but money and shit off the roof above a specific window. That's where it's found. I think it's clear that he's talking about these scissors. They're, as you noted, they're wrapped in saran wrap. That sergeant at some point found a towel and rubbing alcohol, which, you know, again, circumstantial, but I think goes to show that he was he hid this weapon for a very good reason. And that's just for reference. That's Jury Trial Volume 1, pages 244 through 247. And OV-7, I wasn't aware that we were going to be arguing Vahovic, but fortunately I was on that case. I argued it in Detroit, and I conceded error on that, in that case on OV-7. This is a much different case. And the only thing I wanted to note was on the bottom of page 19 of defendant's brief, he attempts to distinguish Clark by saying Mr. Holmes did not continue to attack an unconscious person. And the timing's a little unclear, but I think that's pretty much what defendant did. The victim essentially testified this, and I don't remember if he testified that he woke up to being kicked in the face or he wakes up and then he's immediately being kicked in the face. But I think that's kind of dead on point. Clark is dead on point on this. And as you noted, Judge Schwartzel, he had just horrible injuries from that. This is well after the stab wounds, well after there's any danger to defendant. And I think that clearly justifies the scoring of OB7. Any questions?
Thank you.
Thank you very much.
Time for brief rebuttal.
Just really quick on the OV7 and the Clark case. I think these cases are very different. The Clark case involves someone being kicked repeatedly in the face and head with steel-toed boots, shattering all the facial bones, and beating the victim so badly that he was killed. In this case, we have the complaining witness who either woke up to being kicked twice or was awake and was kicked twice, got back up, continued to threaten Mr. Holmes after. So these kicks happen in the middle of a mutual combat. He was not on the ground where Mr. Holmes comes and finds him and continues to stop and stomp on him. And I think the steel-toed boots does make a difference here. Repeated kicks to the face with steel-toed boots is pretty excessively brutal, I would say. But in this case, we have the complaining witness started the fight at Mr. Holmes' house trying to take his son. Mr. Holmes continued the fight until Mr. Kane left. He didn't pursue him after that. The kicks were to finish the fight and make sure that he leaves. And right after Mr. Holmes and his girlfriend, the stepdaughter of the complaining witness, said, "Would you like us to call an ambulance or call the police?" The complaining witness responded to that by, again, threatening Mr. Holmes' life. So a mutual fight with continued threats from the complaining witness is very different than someone being beat to death while unconscious with someone's steel-toed boots. So I do think there's a distinction to be made there.
Okay, thank you. All right, thank you.
Thanks, Your Honor.
We appreciate the everybody traveling and the roads, and so we very much appreciate you being here and answering our questions. That case is submitted. Calling the eighth matter on our docket this morning, docket number 372705, the ACLU of Michigan versus the City of Taylor.
May it please the court, Mark Fancher appearing for the plaintiff appellant, ACLU of Michigan. Your Honors, this case revolves around a very simple FOIA request that was directed to the City of Taylor.
I don't mean to interrupt you. It does seem quite simple. We see these, I sat on the Court of Claims. I know Judge O'Brien sat on the Court of Claims. We saw these FOIA cases all the time. And this seemed to be just a run-of-the-mill FOIA request. I think you have a fairly strong argument.
Well, we've always thought so, Your Honor, and have been quite surprised that the City of Taylor has resisted so fiercely and so strongly and so stubbornly. And the only thing that we can conclude is that it is a reaction to the historical context and the relationship between the ACLU of Michigan and the City of Taylor.
I get that, there may be some antagonism there, but that's no excuse for not responding to what seemed to be just a plain vanilla FOIA request.
There's not much more to say, and other than to just note for the record that as far as the appellant is concerned, the error below is that the court treated this as some type of factual question, when in fact it is a question of law, that she should have just ruled on summarily and we would have been finished, but here we are.
You'll have time for rebuttal.
Thank you very much, Your Honor.
You hear from the city's attorney?
Good morning. May it please the court, Amanda Waske on behalf of the City of Taylor and the City of Taylor Police Department. I guess I would like to just start by saying I don't agree that the court erred in finding this was a question of fact. I think the court summarily dismissed because as a matter of law, Judge Hathaway found that the request was not sufficiently specific, such that the city could identify what documents were being sought.
I mean, we see these all the time, and this seemed pretty straightforward. It didn't ask for information about any incident of profiling or discrimination. It's, were there any allegations or findings of profiling, discrimination, harassment, or excessive force? I mean, that would just be looking at, you know, were there any internal findings? Were there any reports? Or were there any complaints that were lodged? And just looking for, you know, through the records to see if any of those hit.
Well, and I think to your point, Judge Schwartzel, you have narrowed the request sufficiently such that a clerk probably would have understood what type of documents were being requested.
Right, but I'm literally just reading what the FOIA request was. I'm not trying to modify what the ACLU said. I mean, it's
Right. And listen, as you know, I don't think the defendants can ever contest that FOIA is a pro-disclosure statute. I mean, I also handle these for cities all the time. But that broad disclosure is still contingent upon a sufficiently descriptive FOIA request. And here you have not only the City of Taylor clerk, but the City of Taylor Police Department clerk that helps with FOIA, Mr. Plato, the city's attorney, and a circuit court judge who all looked at this request and said, we don't even know where we would start. And I think it's disingenuous to say the city just thumbed their nose at the request and said, we're not helping you. Mr. Plato did reach out and say, hey, I don't understand. I think this is what you're looking for. Here are some documents. Are we on the right track here? Or could you help us out and narrow your request? And the ACLU was not interested in having those type of conversations. They wanted to just run to the circuit court and file a lawsuit, presumptively because there could be fees associated. And so, you know, I wanted to briefly note that there's a lot of case law cited by the ACLU in their brief. They want to hang their hat on the fact that those words, any and all, appear in FOIA requests all the time and in those unpublished cases where those specific requests were found to be sufficiently descriptive. But those requests also have additional qualifying descriptions associated with them. They're talking about a specific person, a specific event, a specific project. They've identified an author, an incident number, an officer by name or by badge number. Here we have very generally just a reference to anything about racial profiling, discrimination, excessive force.
That's not what it says. Anytime after October 7, 2021, so I think that's a fairly discrete time frame, that in any way concern allegations or findings that Taylor Police Department officers engaged in racial profiling, racial discrimination, harassment, or excessive force. I mean, any way concern allegations or findings, that seems pretty concrete. I mean, like you said, you've done this a lot. This can't have been the first time you've seen something like this.
Well, I did not handle the specific FOIA request. The city attorney did. We are appellate counsel for the city. But I would just say that, you know, when the clerk looks at it and the police clerk looks at it and the city attorney looks at it and they still don't know where to go, they deny the request and they go back to the ACLU and say, can you help us out here? What specifically could you change to help us at least look at the right track and where to go? And where they're met with an unwillingness to do so, I don't think that the trial court committed any legal error in saying that it should be summarily dismissed as a matter of law. I'm not sure if the court is even going to consider the litigation exception arguments that were raised in our brief. I know that the circuit court did not address them, but they have been addressed by both parties below. And so if the court would like to consider it, it certainly has the discretion to do so. The only thing I would want to note in addition to my brief is that the Day case that's cited by the ACLU, it's not published. So it's not binding on this panel. Now, with that being said, I appreciate the statutory construction analysis that the Day court undertook, and I understand how they got to the result that they did. My argument is more of a policy ethics argument, and that, you know, I've always been taught as a member of the bar that if it feels icky or if it's a gray area, don't do it. And I think that the Day court has also expressed it doesn't really feel right, but we feel like we're bound by what the legislature has or has not said here. So I would just note that if the panel is willing to consider the litigation exception here, some additional clarity from the legislature would be helpful, of course, but this panel is not necessarily bound by the outcome that the day court came to. So if there's any additional questions, I'm happy to rest on my brief. Thank you.
Thank you.
Just to note a couple of things for the record, counsel is at a disadvantage in that she is representing this only at the appellate level, but there are some facts that are misstated about how this unfolded. When the FOIA request was initially submitted and we got the initial denial, I personally made an attempt to call the clerk in the police department who had sent the denial. I never received a return call. We did not have any opportunity to hear about what their concerns were after we filed the lawsuit. That's the first time that we heard from Mr. Plato. And it's really remarkable that he stated during the first motion hearing that when this was first presented to him, that he was totally dumbfounded and confused by the language and had no idea about where to begin. But then after the lawsuit was filed and after we had even exchanged pleadings and we were into the case, that he first steps forward and says, well, I think I know what you're looking for. I'm going to make some effort to try it and pull some things together. He can't have it both ways. He can't be totally confused in 1 minute and pretty clear about what it is that we're looking for in the next. The other thing I'll also just note for the record is that with respect to the litigation exception, we do cite in our reply brief, the case of Bryant versus Taylor, where it says that it's appropriate for this to be considered on appeal, not only when the parties address it, but when it has been addressed and decided by the trial court. And we would think that it would be improper for that to be a matter for this court to consider at this time.
Thank you.
Well, thank you very much, John.
We appreciate the argument this morning. That case is submitted. That concludes our 10 a.m. portion of our case call, and we are going to take a 10-minute break. $11:55, so we're not too far behind. Just to go over a couple ground rules very quickly. We've read your briefs, we've read the law, we've read the record. So this is not the time to repeat everything in your brief. It's the time to identify 1 or 2 points that you'd like to stress. If there's been any new case law or statutes that have been enacted or submitted between when you filed your brief and today, or most importantly, answer any questions that we might have. And if there are any minors or victims of abuse, please do not use their names. Refer to them as a person or by their initials. So with all that said, calling the 9th matter for today, docket number 374361, Hawkins v. City of Saginaw. Mr. Hawkins.
Good morning. To please the court, thank you for this privilege of being able to be here to present this very important issues regarding Michigan jurisprudence and how to make sure that justice prevails and its fairness. My name is Stacy Hawkins. I'm appearing pro se as a plaintiff. The case presents 2 pretty straightforward questions. The first is whether I had standing to challenge the unconstitutional seizure of me being pulled over. Why the lower court said that I wasn't detained, I'm not clear. There was clear video evidence that you all have probably reviewed. The second issue is much bigger and much more important, and it's whether I have standing to recover money lost when I posted bail for my wife after police disregarded exculpatory evidence I pleaded with them to look at before bail was even set. And that's
Mr. Hawkins, I think on the first issue, that's pretty straightforward, and I don't know that you need to spend any time on that. So if you want to just briefly highlight your points on the second issue, that would probably be most beneficial.
absolutely. Thank you, Your Honor. So let me put this in a context, if I could, with an illustration. Say that you have a family gathering and the police knock at the door. You've got family there, your spouse and kids are there, been there for a couple hours. The police come to arrest your spouse and your child, saying they were just involved in a hit and run. They took off and fled the scene. Well, you know that they've been there. You have evidence. Your security footage from your home shows that they were there. The police arrest them anyway, refuse to look at the footage, refuse to talk to witnesses that are there. So you're then compelled to go and come out of your pocket, $50,000 for each, to go to a bail bondman to get them out. Well, should you be able to recover that once the evidence is seen by the prosecutor and the case is dismissed? It's thrown out. It's like, this isn't the case. They were not involved. The car's there, no damage to the car. The security footage shows that they've been at the house the whole time. The witnesses say that.
But Mr. Hawkins, I think maybe the fundamental disconnect on this bail issue is that you've not sued anyone who was involved with the bail. You sued the police officers and you sued the city, but none of them set the bail. None of them could have done anything with regard to the bail. And even if their actions led to the proceeding to which bail was set, they didn't have any involvement in that. It was the court and it was the prosecutor. And your client I forget her name.
My wife.
Your wife. Those were the three parties to the bail. And so wouldn't one of those three parties have to be a party to this lawsuit for you to be successful?
Causation. Causation was not caused by those other parties. The sole reason that this took place and that we're here is because the police refused to look at the exculpatory.
Sure, they might have been they may have been involved in the but-for causation. I grant you that. But they had nothing to do with setting the bail. Like you can't recover from them because they didn't receive any of the proceedings. They didn't order the bail. They just didn't have any involvement in the setting of bail itself.
So the issue is not per se the bail. It's the necessity. So let me bring home back to the Michigan Constitution provisions for the fair and just treatment during an executive investigation and hearing. So the police officers were duty bound by the Constitution, and I believe that's protected by the 14th Amendment. They're required to adhere to or comply with the statutes and the Constitution of Michigan. Had they conducted the fair investigation, which includes looking at, not turning a blind eye and ignoring exculpatory evidence, we wouldn't even be here. That's the sole reason why we're here. The police have a duty, and in fairness and justice, every police investigation should be fair. They should never go in saying, well, I don't like this person, or I'm not going to listen to this evidence, or I'm not going to allow the prosecution to get a chance to see the evidence that may change their decision. That's crucial. And in every situation, I apologize for my passion, but this has a personal underlying reason for some of this. But again, do we want to live in a society? Is the Michigan laws, are they geared towards the police getting to do what they want to do, to disregard laws? Or should they, or disregard evidence? Or does the law require them to get the facts? Just be impartial. Just do the job, protect and serve. Just get whatever facts they are. Doesn't matter what the facts are. Just give them to the prosecutor who's in the best position to make a decision then. In this situation, the police didn't do that. They deliberately excluded evidence that they knew existed and didn't want to give the prosecution that evidence. As soon as the prosecution saw the evidence, the prosecution threw the case out, said this evidence favors the defendant. It's exculpatory. Let's get this case out of here.
Okay. I think we understand your position. Let's hear from the other side, and then you'll have plenty of time for rebuttal.
Thank you.
was about to say good morning, but good afternoon at this point.
You are correct.
Jeffrey Wagner appearing on behalf of the Applees. With respect to the standing rationale articulated on the record by the trial court, I don't have a lot to add with respect to what's been previously set forth in the brief. We essentially had what is either a bystander tort or a negligent infliction claim kind of pled in constitutional garb. The trial court's rationale that there's simply no direct evidence of an injury that Mr. Hawkins could vindicate through a constitutional tort on behalf of his wife. I just don't think that there's any law in support of that. I think with respect to standing, the trial court correctly made the decision that this is a case that was ripe for summary disposition. Just a quick matter of just procedural background, the initial complaint was pled under the state constitution. And as my partner John Clark argued in the trial court, there's no mechanism to recover damages under the Jones versus Powell case. The appellant attempted to cure that by attaching a proposed amended complaint to the summary disposition brief, which basically recast the state constitutional claims under the purview of a 1983 claim under the federal constitution. I don't think anything in the proposed amended complaint would establish a prima facie case under Monell to have municipal liability for the city of Saginaw. And likewise, the only instance of a constitutional injury suffered by Mr. Hawkins individually is referenced in paragraph 68 of the proposed amended complaint, which is the reference to him being pulled over outside of I believe a Family Dollar General store for allegedly loitering. The police interact with him for a few seconds, tell him to scram, at which point he goes. He's not arrested. He is not subjected to any type of prosecution. And in order to establish a viable claim against those officer defendants under 1983, he had to appoint a clearly established law that was put the officers on notice that merely talking to him outside the Family General and telling him to leave the premises would amount to a violation of the Fourth Amendment.
But the trial judge, as I recall, kicked everything on standing. Correct.
I think the trial judge's ruling was twofold. One, there was no standing as to the claims that were set forth in the original complaint, which again is limited to the state constitution. I think in an ideal universe, there would have been perhaps a little more analysis to how the claims that are set forth in the proposed amended complaint would have played out. And I'll agree with you, Judge Schwartz, that the record is opaque on that point as best. But in order to have Mr. Hawkins get leave to amend at that stage, he has to overcome a futility argument. And futility was absolutely raised by my partner in the trial court. And in order to establish a viable constitutional tort for the conduct set forth in paragraph 68 of the amended complaint, you'd have to make more thorough showings under Monell. You'd have to make more concrete and specified claims to get past qualified immunity. So I would think
those are all issues that are not before us. I mean, as I recall correctly, we have standing. That is the question we were being asked to look at, is whether there's standing here. Monell, qualified immunity, those are all further down the line if this were to even go back. But why don't you focus on the bail bond issue? Because I think that's what Mr. Hawkins was spending a considerable amount of his time on. So why don't you address that?
Sure. Mr. Hawkins used the word causation. And in order to establish a constitutional tort against the city or the officers, he'd have to establish that he himself was injured as a result of, he may have a direct breach of contract for failure to repay a loan to his wife. It would be odd. I don't think any husband would do that, nor would I imagine that he would. But to the extent there's a claim, it would be against the bail bonds company. It would be against the individual, in this case, his wife, to whom he loaned the money. I fail to see a connect between the actions of the city of Saginaw Police Department and its officers and Mr. Hawkins being out several $100s for stepping up and contributing to the bond issue. I don't think there's been any direct injury recognized by our court standing jurisprudence that would allow him to recover that money through the, through the vehicle of either a state or a federal constitutional tort. Not aware of any law that would support that. And I think the court's standing analysis on the bail issue was spot on and consistent with the applicable precedent.
Okay, thank you.
Thank you.
Mr. Hawkins, you have time for brief rebuttal.
The case Lansing Education Association, Michigan Supreme Court ruled, it was against the Lansing School Board, that there are 3 criteria for standing. They're pretty liberal, and a person has an injury. I asserted what that injury is. You've read the briefs and the facts. This wasn't a loan to my wife. This was money I came out of my pocket because my family was placed in this position. It's different from members at large of the public. This was specifically me giving the police the exculpatory evidence that I had investigated. I said, here, you didn't do it, I'm going to do it. Here's this witness. Here, talk to this person, get all the facts. Whatever it is, get all the facts, and then present that to the prosecution or whomever so that they can make a fair, reasonable decision. The sergeant, whomever, moved the ball up later to keep her confined until bail was ordered or set. So the standing as provided for or required of the 3-prong test, again, the 3rd prong that I haven't mentioned or referenced yet, is a person being willing to vigorously litigate. Well, clearly that's present in this case. So the 3 elements required by the Michigan Supreme Court for standing were present in my situation. This isn't a case where my wife has her own thing that she can deal with them with. I'm talking about my involvement in getting the bail and having to post a bail after asking officers to look at the exculpatory evidence. Again, I'll go back to that analogy that I used earlier. Who should pay? Who's responsible? What should the law be for the state of Michigan? What compunction or responsibility does law enforcement, therefore the city who's in charge of them, have? That's where it stops. It wasn't the fault of the courts, the people, or the prosecution who acted according to their duty. It was the individuals who acted outside of that duty. And there are clear laws. There actually is a ruling by the Sixth Circuit and Logson, and I forget, I believe maybe US, that required law enforcement to look at exculpatory evidence. There is precedent for this. Longstanding, I think it was ruled on in 2007. So this has been out there for some time. This isn't new. And just inherent fairness and fair justice. You look at all of the facts in conducting an investigation.
Okay.
Thank you, Your Honor.
All right.
Privilege.
Any other questions? All right. Thank you. Thank you for your argument. It's been very helpful, and we appreciate your appearance today. That case is submitted. Calling the 10th matter for today, docket number 368468, Hoffman Machinery versus Reed Machinery. Wagner's just changing sides.
Yes, I was joking with Mr. Gibson, who I've known for a number of years. I was going to get my cardio in for the day, going back and forth between the 2 tables. Good afternoon again, and may it please the court. Jeffrey Wagner appearing on behalf of the appellant Reed Machinery. Your Honors, this is a fairly interesting business dispute that took place over the course of just shy of a month in the summer of 2021, which centers on a roughly 6,000-ton piece of metal known as an Ajax press. Perhaps the court did. I learned some new vocabulary getting up to speed on this case and learned about forging and riggers and some interesting terminology. And that specific factual context of this case, with being from a temporal perspective, roughly 30 days, and a truly huge piece of equipment that is by no means easily moved, is something that, from the appellant's perspective, the trial court failed to properly place this case in its proper context and really focus on the particulars of the type of property that we're dealing with, as well as the very condensed window, which involved the work trip for my client's representative, as well as a wedding he was planning for his daughter. And we threw a lot of paper at the court and did our best to brief the issues as thoroughly as we can. And I know from watching the arguments that preceded our case that the court's read everything. I want to focus most of my attention on what, from the appellant's perspective, is the most problematic aspect of the court's legal reasoning in its lengthy opinion, which is the issue of the demand and the refusal. This is a conversion case that arises out of a bailment. And as we explain in the brief, because of that specific legal context, the plaintiff had to establish two conditions precedent before it could establish a viable conversion claim of the equipment. The first, an affirmative demand, the second, an unqualified refusal. And failure to prove or establish either of those would be fatal to the claim. And trial counsel, Mr. Lovejoy, moved for summary disposition on that very issue below. And if we look at the voluminous record in this case, we see demands that relate to an inspection to come to the property and see it, but it was a two-part multifaceted process. There was a request to inspect to come see it, which we would submit was made by the representative of Hoffman. And in response to that, my client, although I think if he had it over to do over again, he might have acted differently, but there's a distinction between actions and words, and actions tend to speak louder than words. There are some colorful emails which perhaps don't paint Mr. Reed in the best light, but at the end of the day, it's undisputed and established from the record that exists that multiple inspection requests were granted. Jason Rotten from RJ Industrial, who has been to the property before, went out, saw the Ajax, put together a very specific quote that he was ready to act on in the event that he had been given a chance to do so. And likewise, Tim Pauser, later in the month from ICCC, had a chance to look at pictures, didn't get out there physically to inspect it, but was able to put together a quote to take the Ajax off of its rail car on which it sits so that Mr. Routon could scrap it and do what he does as a metal scrap. And if we look at the cooperation that was inherent in allowing those two things to do, I think it is specifically in contrast to the description of Mr. Reed that it appears in the trial court's opinion. I think the court was essentially unfairly harsh with him and was very critical of Mr. Reed and accused him of playing games and obstructing the process.
He really did obstruct the process. I mean, I don't see any other way to look at it. He's the one that set the deadline of August 1st of 21, that if it wasn't moved by that time, some ridiculous amount of rent, $15,000 a month, was going to be charged. And then a week or two into this whole process, when the plaintiff is asking to send people out so that he can get quotes from other people, Reed says, no one's going to be doing the rigging except my company. But then he wouldn't give a quote. So he kind of set a trap. That's how I look at this. He set a trap for him. There was nothing Hoffman Machinery could do. He had no choice.
I think if we, again, I would go back to the distinction I attempted to draw between actions and words. Admittedly, the email correspondence don't particularly help my client's position. But if we take a step back and look at what actually transpired as feet were on the ground during that month, we did have people come in. Quotes were authored. And again, I think the most important part of
Not from your client. Your client never gave a quote for the rigging. And he ended up saying to Hoffman Machinery, no one's going to do the rigging on our property except us.
There was some haggling back and forth during a period where my client was either out of state doing work or planning his daughter's wedding. And I'll be the first to concede, Judge O'Brien, that if he had it to do over again, the email correspondence would look differently.
Maybe if this haggling was truly being done in good faith on both sides, and your client was busy during the month of July on work trip and his daughter's wedding, maybe your client should have not set an August 1st deadline. Set it for September 1st and let the July events pass. And then you can, engage in good faith haggling at the end of July and through August. But that's not what happened here. And that's not what this record looks like. And even if we were to see it more in your light, This was a bench trial, if I recall correctly. You know, the judge made findings, made calls with regard to credibility. We can't pierce that. There were a lot of factual findings that went against your client that, you know, again, even if we heard the evidence anew, we might go in a different direction. But that's not what we do on appeals. We look for clear errors here. So where is the clear factual error that the trial judge made here?
The clear error from our perspective is the most notable one that jumps out to me when I'm reviewing the trial court record is the analysis of the refusal issue. We dedicate a good chunk of our brief to the distinction in the various bailment treatises, both Michigan and nationwide, that make a distinction between a qualified refusal and an unqualified refusal. And if we look at I spent a lot of time and had some summer associates help me digging into the research on this one, and we've not found a Michigan case that addresses, it's section 238 of the restatement that talks about qualified versus unqualified refusal. But if we look at what actually transpired, there was never a situation where it's two things. By way of comparison, we cite to some cases where you did have an absolute express position statement made by the plaintiff. And we cite two cases out of the Eastern District. I think one is written by Judge Michelson, the other by Judge Beckering, where the plaintiff says, all right, defendant, release the equipment by 2:30 today. Otherwise, we reserve all rights and we're going to sue you conversion. That never happened. I think the analogous case from the qualified versus unqualified refusal treatise is the one out of the Underwood case out of Colorado, where you had a huge collection of computer equipment and the plaintiff basically said, I want my stuff back. And the defendant said, well, that might all be well and good, but before we do that, we need to do a wear and tear analysis. And there were a host of things that needed to happen before we'd be in a position to return the property. And I think the Underwood case is a good comparison to what happened here, where in order to actually get
this Colorado case, was there the threat that if you don't get the personal property off the real property by a certain date, that the rent will be jacked up to a considerable amount?
That did not appear in the Colorado case.
That's the trigger here, is that you have this deadline. So Hoffman has to get this equipment removed by August 1st. And it doesn't seem like your client was cooperating in any way, shape, or form to permit that to happen. And if there was no overhang of this rent being jacked up from a couple $100 to $15,000 or more, okay, maybe that's just, again, like you said, haggling. But there was a deadline with a huge financial penalty, and it doesn't seem like your client was enabling Hoffman to meet that deadline.
I think the testimony in the record from Mr. Reed and his associates at Reed Machinery is that they, as of the time that this lawsuit was filed and it's interesting. So we cite in our chronology in our timeline that as early as July 13th, Hoffman's lawyer is working up this lawsuit and getting it ready to be filed in the Ingham County Circuit Court. And at no point in this roughly month-long period do we have a specific statement that says, let ICC and RJ in to move this equipment. And we know that, in fact, Judge Schwartzel, you used the words both sides in one of your questions earlier, and we absolutely have evidence of lack of cooperation and questionable business tactics on both sides of this case. We know from the record that Hoffman had multiple quotes in hand and admitted that he, quote, kept Reed in the dark, end quote, as to those quotes. Why? I don't know. I have certain guesses as to that, but I'm not in a position to do that today. But we do know that at the time this lawsuit was filed, there was never an instance where Hoffman said, let RJ's and Tim Pauser in to move this equipment. We knew it was going to take 30 grand for Tim Pauser's company to move it, and that after RJ Industrial scrapped it, Mr. Hoffman was going to end up with the scrap value of the Ajax, which as of that time was about 80 grand. I think at the time of trial it had reduced to 50.
So in the absence of that clear demand, you believe the trial court clearly erred?
I do. I think when we're dealing with a case that lives on the often blurred line between contract law and tort law, I think it's important that our legal standards have clear and bright lines so that we don't run into a situation where what ought to be a garden variety business dispute over 80 grand, over a piece of property that's worth 80 grand, goes off the rails and becomes a $500,000 tort claim with treble damages and attorney fees. And I'll be the first to admit that Mr. Reed could have done things differently in terms of the haggling process. But at the end of the day, I think it's important that our law, as it relates to commercial disputes, provides certainty and clear, bright lines to guide businessmen in the course of their affairs. And I think by having a situation where you've got an ambiguous standard here, it allowed for Mr. Hoffman's extremely capable lawyers to deal with this situation by, in my view, manufacturing a conversion dispute for the sole purpose of going after treble damages and attorney fees. And again, to go back to one of your earlier questions, Judge Schwartzel, which I'm not sure that I answered, agree with you completely. Bench trial, factual findings made by the trial judge are entitled to deference by this court. But there are legal issues related to the court's analysis, specifically on this issue of at what point do we allow a contract case to become a tort case that opens up a completely different universe of damages, and it, from our perspective, completely destabilizes an industry that would benefit from having clearly defined bright line rules. Just briefly then, I want to touch on the treble damages and attorney fees. Again,
did you want time for rebuttal?
I will, with that nudge, I will sit down and save a few minutes for a rebuttal then.
Okay, thank you.
Thank you, Your Honors. Ron Nixon on behalf of Hoffman Machinery. I said pretty much everything in my brief, and you basically just made my argument for me. I mean, in asking the questions that you asked. I mean, since the complaint was filed, we've been telling the exact same story. We told it in 4 briefs, including one for summary judgment, which dismissed their counterclaim, which they litigated for 1.5 years, stating that they were entitled to back rent, and that they were entitled to do the rigging when it was removed. They litigated that for 1.5 years until Ed Reed's deposition, when he said, oh, that was a lie. So we got that claim dismissed. And actually, I think they stipulated to it after we filed our motion. You know, then they appealed it to this court. I wrote another brief. It's the same brief. If you read all those briefs, we tell the exact same story. And then after hearing all the arguments, evidence of both sides, the judge's opinion tells the exact same story that we've been telling from all along. There's no other conclusion that could be reached from this evidence. And as far as the demand, our very first letter on July 6th, we said Jason Ruffton wants to come in and look at the piece to give a full estimate. He could do the work on the week of July 12th, so time is of the essence. What is that? And we asked Ed for his quotes like he promised, or Reed Machinery for the quotes that they promised in their initial letter, jacking up the rent by 850% of one of the things, and then 15,000 from zero.
You did get a quote in writing, but was it several months afterwards?
That was after the lawsuit started, and it was still the outrageous quote.
No, I'm not asking you about the level, but if I remember right, this was all going on in July, and then around October.
October is when their attorney emailed us.
The attorney provided it.
But that quote, mind you, this was a slight error in the court's opinion. That quote was only for removing the Ajax machinery, not the frame. And the frame was the biggest part of the job. So we still had no quote for the frame. So where was I? that was a demand by any stretch. And then our July 10th letter confirmed, look, we've had a course of dealing. You've never been the one, to demand that only you rig it. And this was after he had already said that in an email that he was the only one who was going to be allowed to do it. Why are you putting these impediments when you impose this condensed deadline on us to get our stuff off the property? So let's do it. Cooperate. Give us your quote. Let our guys on. So after that, they're claiming, oh, he cooperated. He let our guys on. Two of them he talked to and said nothing was going to be done until we worked out some agreement as to the back rent or something for compensation. And the other one he convinced not to do the job at all, and according to the evidence. So for them to claim that there was not a demand and a refusal with the condensed timeline, I almost hurt my eye muscles rolling my eyes when I read that argument. So anyway, I've said almost all of this in the brief, so I'm going to rest on the brief unless you have questions. Thank you.
Thank you. You have time for brief rebuttal?
So, Your Honors, the court has made it clear from its comments that it takes issue with some of the things my client did during this months-long period, and I can totally understand that. But at the end of the day, in order for a tort claim to arise in this context, we need evidence of active misfeasance, something more than just failing to deliver the property or arguably putting up some type of roadblocks from a failure to respond to the emails in a prompt way. And as we note in our reply brief, the decision from this court in a case called 1-800-Bathtub LLC versus Rebath, there's no published authority from this court that addresses the misfeasance, nonfeasance test from the Hart case in the context of a statutory conversion case. And if we look at the unpublished authority that does exist in the cases where this court has found evidence that is sufficient to give rise to statutory conversion, it involves affirmative tortious conduct that's different than what happened in this case. In the Aroma Wines, wine was moved to another facility and destroyed. In the Working versus Working case, another unpublished decision from this court, and one of the most unusual fact patterns I've ever looked at in my life, it was a dispute between a mother and a father and their adult son over his pornography collection. They destroyed it, they threw it away. He sued them for conversion, and they found that the act of physically destroying it, it was evidence of active tortious conduct that would give rise to a tort claim. And aside from a few, in retrospect, emails that probably should never have been sent, we just don't have that here. And Mr. Reed testified that if Hoffman had simply reached out to him, called them and said, let RJ and Pauser in to move this, he would have let him. He said in his during his testimony from the trial court, I had no problem with them. Them three are all good riggers. So I think if we look at the totality of the evidence and we place this case in its appropriate factual context, which again is less than 30 days over the course of a busy summer month, and its appropriate legal context, a bailment business dispute that involves claims for statutory conversion without any active tortious conduct in the way that we've seen in Aroma Wines and its progeny, I think the record contains ample evidence of errors that should be remanded to the trial court for further proceedings. And with that, I thank you all for your time.
Okay, thank you. No. If that was the standard, half the conversation during our oral arguments would be struck. So that case is submitted.
Thank you, Your Honor.
Calling the 11th matter for today, docket number 370896, Lori Jo Welsh v. Ariana Welsh.
My understanding that my opponent is going to.
Good afternoon.
All right. Is it Miss Bollier?
Yes, Boyer.
Okay. You may proceed.
Thank you and good afternoon. May it please the court. My name is Fatima Boyer and I represent the appellants in this matter, Ariana Welsh, Thomas Welsh IV, and Tori Welsh. I realize the parties have thoroughly briefed this matter, so I will focus my argument today on addressing a couple points from Appellee's response brief and answering any questions that the court has.
Okay.
As we discussed in our brief, this case deals with a land contract among family members. There were several cases with the family, the Welsh family, and so because they all have that same last name, I will refer to them by their first name and do so with respectful intent. So I wanted to just briefly say that we do not dispute that Michigan gives significant deference to arbitration awards. Even though we are disputing the arbitration award here, we acknowledge that there is significant deference to arbitration awards. What we are disputing here is the fact that, as we argue in our briefing, deference to arbitrators does have a boundary, and I will not get into the laws. I know the court knows that. And we feel that here, the arbitrator made an error of law, and that his rulings were in contravention of controlling principles of law and should therefore be set aside. As we set forth in our brief, there were three issues that we believe came up with the arbitrator's judgment. First, the arbitrator allowed Miss Lori Welsh, the appellee, to bring and maintain a land contract forfeiture, even though she did not own the property and never proved an assignment. And that is the main point that I will be focusing on today and responding to some of the arguments in appellee's brief. But just quickly, our second argument is that the arbitrator's judgment created an escrow structure that appears nowhere in the land contract or in the summary proceeding statute, and that would also be in violation of MCR 3602J. And that third.
Ms. Bollier, just jump into the arguments. You've kind of given us an outline of your brief, but we don't need that. Just jump into the argument and let us know. Sure. I think you said you wanted to respond to the response. So go ahead and do that.
Yeah. Thank you, Your Honor. So the appellee's response brief makes two main points. One, that she had standing because she had an assignment, and also that appellants waived their standing claims. So just quickly responding to the assignment issue, Miss Lori Welsh does not deny that she has to have standing, and it's undisputed that she brought her action pursuant to the forfeiture statutes. She just claims that, well, I had an assignment. However, as we explained, there has never been an assignment produced anywhere in the lower court. And as we set forth, as I like to point out in Exhibits 2 and 3 of the appellee's appendix, it shows that when appellee filed her forfeiture notice on December 3rd, 2021, she indicated that she was the seller of the property, not the assignee of the seller, which is a box that she could have checked in the complaint form. And again, just a couple weeks later, when she filed her complaint for possession after land contract forfeiture, she again indicated that she was the seller of the property, not the assignee. And lastly, on the assignee issue, the arbitrator himself acknowledged that Aaron, quote, never asked Lori to forfeit the 2004 land contract, end quote. That's in Appellant's Appendix 6, opinion page 13. And so if the main argument of appellee is that she had standing because she had an assignment from the true owner of that property, there is just no evidence that existed. And so for the arbitrator to have relied on that, we believe was error. Second, Your Honor, Your Honors, appellee relies on an argument that appellants waived standing arguments for a number of reasons. Just very briefly, as we set forth, we did plead that in our first responsive pleading, and I think that it's a little bit more nuanced than what Applebee's would have this court read it as, because the arbitration was actually 5 cases. And the first case was the forfeiture case, but there were multiple cases after that, which also involved standing issues. So standing was a issue throughout the arbitration. And while we pled it in our first responsive pleading, it also came up multiple times after that. So I wanted to explain that because I think it is a little bit nuanced, and to just say it was waived because we didn't plead it sufficiently in our first responsive pleading. It came up numerous times throughout the arbitration. We also get into law about that standing cannot be waived. And so those are Applebee's 2 main arguments in their brief. They then go on to discuss my clients, the number of motions they filed. We do not think that is relevant. And so we do not feel that needs to be addressed, but my clients did have a right to file the motion that they filed, and we feel that that's just attempting to poison the well. So if the court does not have any questions, then I will rely on my briefs for the remaining argument.
Okay, thank you. You'll have time for
Thank
rebuttal.
you.
Good afternoon. May it please the court. Tim Orlando appearing on behalf of the plaintiff appellee, Lori Jo Welsh. I believe that the facts and the procedural history are all set forth in great detail in the briefs, and I'm only going to address the standing issue unless any of you have any other questions. In terms of the assignment, standing was never raised as an issue until July 2023. The arbitration took place in June of 2022.
What about opposing counsel's argument that it was in the pleading?
It was raised as an affirmative defense.
Okay.
There's no doubt. It was never raised as.
That was it until well after?
Well after the award was issued. And in fact, as Judge Switalski pointed out in subsequent opinions, it was never raised in the 42-2 district court when we were there. It was never raised during the arbitration hearing itself in June of 2022. And there was never any point where anybody asked about an assignment until, again, July of 2023. And we rely on the Glen Lake Crystal River watershed case that essentially says if you wait so long, you arbitrate, you do discovery, you file an answer, you litigate the entire case, and ultimately you have the arbitrator issue an award. You can't wait another year and say, oh, by the way, you never had standing to do this. The award was done. The arbitration was over, and we were really fighting over whether or not we were going to be able to have the award confirmed and a judgment entered. And ultimately, that's where we ended up. It's not the fact that they didn't plead standing. It's the fact that they never raised it timely. They never raised it during a point when we were dealing with the issues of the case. Other than that, I stand on our brief. I believe we've addressed all the rest of the issues.
Any other questions? Okay, thank you.
Thank you.
Ms. Bollier, brief rebuttal.
Thank you, Your Honors. I would just say that we list cases in our brief that explain this kind of standing defense cannot be waived. I understand that Appellee cited Glen Lake. Glen Lake, that's a case dealing with the party's legal capacity to sue, governed by 2201C, as opposed to the type of standing that we're dealing with here. But we go through those cases in our brief, and so I will not take any more of the court's time. Thank you.
Thank you. Any other questions? All right, that matter is submitted. Thank you
Thank you.
for the oral argument. You too. Raising the 12th matter on our docket today, docket number 371220, Jones v. Homeowners Insurance Company. I believe we have Mr. Payne, who is appearing remotely.
You sure do, Judge. Good morning.
It is afternoon. Good afternoon.
Oh, good afternoon. I apologize.
Please proceed.
Well, good afternoon, Your Honors. I did go out of my way to provide a comprehensive procedural history for this case in my brief because it is quite old, and this is the second time it's been to this court. I do just want to start by asking whether there are any questions about the case's procedure or posture that would be important to address before getting into substance.
No, I think we can just get into the substance here. We understand this came up, went back down. But you know, why isn't it appropriate for the judge to say, you know, there should be a bond here because the claims look maybe not so weak to dismiss on summary disposition, but otherwise look somewhat weak?
So, great question, and I'll answer that directly, even if it's going to take me a minute or two. So the first asserted error with that ruling is that the trial court granted the motion for security, even considering the medical records and surveillance as substantively admissible evidence. I'm going to start with that premise. So even with that erroneous consideration, the trial court did still abuse its discretion in granting the request. The order was premised on the trial court's belief that plaintiff will be liable for attorney fees under MCL 500.3148 sub 2. However, sanctions under that provision, according to binding precedent, are only available post-judgment and thus should not be considered as recoverable expenses on a security motion. Further, even post-trial, after a jury finding of fraud, these sanctions are discretionary, not compulsory. It is quite literally impossible for the trial court to exercise any sort of discretion without first having seen the factual record and there being a factual finding of fraud before it can properly evaluate in its discretion whether sanctions would even be appropriate. Still further, even if plaintiff were to owe the $25,000 in attorney fees that the trial court awarded as security for costs in this case, his PIP claims are still almost $150,000. The statute expressly allows any claim for attorney fees as a sanction to be set off against PIP benefits that are owed. So requiring a security bond is unreasonable when the amount of $25,000 is much less significant than the amount of PIP benefits that are claimed to be owed. Substantively, as to the alleged false medical records, clearly plaintiff did not create those documents or submit them in support of any claim for PIP damages. And again, based on the hearing transcript, it seems clear the trial court relied on the surveillance anyway. So regarding the surveillance and plaintiff's alleged physical limitations, I need to make it very clear. Plaintiff never made claims for work loss, household services, or attendant care. There was a short period of time that a third-party facility sought benefits for attendant care, but that was before any of these surveillance even occurred. There are a couple of procedural challenges here as well. First, the surveillance is inadmissible because all three defendants claimed privilege and failed to produce it in discovery. Binding precedent in this state is extremely clear. A party may not secret information by claiming privilege and subsequently waive that privilege. The surveillance can't even be considered. It's inadmissible at trial, and it can't even be considered for security purposes because the jury is never going to see it. I do want to mention this result is consistent with the Butt case that I've cited in my brief. It's the only argument I've ever seen to counter my argument here. But the distinction, the fatal distinction, is that in the Butt case, the surveillance was never requested in discovery. It was never refused to be produced based on a claim of privilege. In this case, all three insurance companies were asked for surveillance. All three insurance companies failed to produce it, citing privilege. They can't waive that later. The surveillance is inadmissible. Very briefly, there's a separate argument. I think the surveillance is inadmissible because it is hearsay. The rule specifically says hearsay includes or a statement includes nonverbal conduct, and it is being used for the truth of the quote unquote truth of the matter asserted being what plaintiff's condition is. The surveillance remains improper to be admitted into evidence for the purpose of determining the plaintiff's physical condition. And then very lastly, Your Honors, I think it was error for the trial court to refuse to acknowledge my client's affidavit that he was financially incapable of posting the bond. So even if a bond were appropriate in the first place, my client can't afford to pay it, and that means it's not supposed to be ordered. And the trial court's basis for this was that the affidavit was provided only on reconsideration. But I submit to this court, how could my client ever swear in testimony that he can't afford a bond before the amount is set? I think it was an abuse of discretion to refuse to acknowledge the affidavit of financial inability because it couldn't even exist until the court determined an amount. That's all I have, unless the court has any questions.
No, you'll have time for rebuttal.
Thank you.
Defense counsel.
Lasky was here earlier, but I didn't know she was going to stick around. But may it please the court.
It appears she has not.
No, I guess not. No. May it please the court. Nick Tatro on behalf of the Hartford, appellee of the Hartford. Your Honor, or Your Honors, thank you again for having me here today. It's not very often anymore that I actually get to stand in a courtroom, so I appreciate that. Thank you. This case has a long history. I've lived it all. This isn't a question of whether fraud was committed. The Court of Appeals previously concluded that. The trial court previously concluded that. It's clear. And in light of that, the appellees had asked the trial court for security for costs, given that we believed that we had a very strong case and the case that was being presented by the plaintiffs was not founded on fact. And the trial court, in its judgment, granted that and granted a very, very modest and reasonable security for cost of $25,000. $25,000 might have covered one of our attorney's fees, might have covered some of the costs associated with the number of experts.
What about plaintiff's argument that the attorney fees would not have been recoverable?
So, yes, and we certainly addressed that in our brief. The homeowner's attorney also addressed that in their brief. I don't have much of anything different to say other than that is not what the trial court stated as the sole reason for giving the attorney's fee, the security for costs, as is stated by counsel.
So medical expense or the cost of having a medical expert review medical records, would that have been recoverable, or could that have been part of the bond?
Yes, and that's again in my brief I lay out. We had I think something along the lines of 17 experts teed up for this particular matter. There was multiple issues, multiple claims of different body part injuries by the plaintiff: his head, his shoulders, his knees, and his back. And so we had a expert aligned for each of those body parts, along with other more fact-based experts with respect to the accident itself. And so, I mean, just the cost there of one, to the Davena essay depositions, the transcripts, the appearance fees for one of the appellees.
What about the trial courts not taking into consideration plaintiff's financial situation?
So yes, and again, we asked. Well, actually, I just piggybacked on the motion below. So it was homeowners that asked in their motion for security for costs for $25,000, that specific number, and that specific number was granted. If there was a known inability to pay, that should have been part of the presentation in contra to that motion. And that motion sat and languished for some time while the parties mediated. So at any point, a extra brief or even an oral argument could have been made. Hey, we can't afford this. there was no assertion of, we can't afford this, but we can afford something less,
So
right?
the request for 25K was out there for several
Correct.
months.
Correct.
And so, and if I recall correctly, the identification of financial inability to pay wasn't raised until the motion for reconsideration.
That is correct, Your Honor. Yes, yes. And so we believe that it's not properly preserved. And frankly, the court rule that appellant's counsel raises to say that if, you know, it's not mandatory that the judge say, you can't pay, so therefore I'm not going to grant this. It's discretionary. There's a may in there. And so it's for those reasons that, again, we thought that the trial court had ample discretion to do what it did. It's certainly amongst the many reasonable principled outcomes that it could have reached below. It was appropriate, and hopefully it puts an end to this case that's been going on for far too long. Any other question?
Thank you. Mr. Payne, you have time for brief rebuttal.
Just 2 quick points. There was no determination of fraud by the Court of Appeals in the prior appeal. The judgment or the trial court's ruling was simply vacated because it wasn't legally available regardless of the facts. And then as to the court's concern that the request for a $25,000 bond did predate the order, this court, I'm sure, is extremely well aware. Motions get denied, requested relief gets modified, motions can be granted in part and denied in part. The fact that we were opposing the request entirely based on the substance. There was no order for a bond. We couldn't provide sworn testimony to a particular amount without knowing whether there was going to be a bond or in what amount.
Thank you. Any other questions?
No.
Okay, thank you. That case is submitted.
Thank
We
you.
appreciate the oral argument. So thank you for appearing both remotely and in person. Appreciate it. That case is submitted. Calling the 13th matter on our docket today, docket number 371392, In re Martin Smutek Feemster Miners. Oral argument has been waived in that case, so the matter is submitted. And I had 14 listed on my docket today, but I was communicating with my JA and she reminded me that this case was dismissed, so we will not be calling them. And with that, I believe we are finished.